Court records are meant to show how justice is delivered, but not every case ends with a ruling. Some outcomes are decided so quietly that by the time they are visible, there is nothing left to challenge. These are those cases. This is what happened before the gavel fell.
The final document arrives without ceremony. It does not look different from the others. It does not announce itself as an ending. It simply arrives. Daniel Reyes reads it slowly, standing in his kitchen, the paper held loosely in one hand. He does not sit down. Sitting makes it feel finished, and he is not ready for that yet. The notice confirms what weeks of silence have already suggested. Final administrative action has been completed. No further proceedings are scheduled. The matter is closed for purposes of court action. Daniel notices what the notice does not say. It does not say guilty. It does not say innocent. It does not say justified. It only says complete. He reads the language again, not looking for explanation but for implication. He has learned that implication is where the truth hides now. There is no summary of testimony, no weighing of evidence, no reasoning attached, just confirmation that the process has concluded. Daniel calls his attorney, not with urgency, but with a kind of exhausted precision. There is one question he has been carrying through every episode of silence, every delay, every unanswered email. When did this actually end? He asks. The attorney is quiet for a long moment, not because they don't know, because the answer reframes everything. That's not really the right question, the attorney says carefully. Daniel waits. The question, the attorney continues, is when it stopped being undecided. They begin reconstructing the case together, not emotionally, but structurally. They pull up the timeline step by step, removing the story Daniel lived through and replacing it with the one the system recorded. They start at the end. Final administrative action, then move backward. Procedural alignment, extended delay, interim compliance, transcript finalization, early continuances. Each step fits perfectly into the next, too perfectly. Daniel notices something disturbing. At no point does the system appear to be choosing anymore. Everything is simply continuing what has already been set in motion. The attorney scrolls further back, past documents Daniel has seen, into internal entries he never knew existed. Notes meant for workflow, not explanation. Then they stop. There, the attorney says. Daniel leans closer to the screen. It isn't a ruling. It isn't a hearing. It isn't even addressed to him. It is a single internal notation. Administrative. Unremarkable. Case posture. Stabilized. Daniel stares at the word. Stabilized. He asks what that means. The attorney explains that stabilization is not a decision in the traditional sense. It is an internal determination that the case no longer requires active evaluation. Once a case is stabilized, the system shifts from deciding to maintaining. Daniel checks the date. It is earlier than he expects. Earlier than the transcript. Earlier than Emily's testimony. Earlier than custody was ever discussed. That doesn't make sense, Daniel says quietly. The attorney explains patiently. Once stabilization occurs, everything that follows exists to support continuity. Hearings still take place. Documents are still generated. Opportunities are technically provided, but the direction is no longer in question. Daniel feels something settle in his chest, not anger, understanding. He thinks back to the early continuances, the calm tone, the absence of urgency, the way no one ever seemed surprised by what came next. It wasn't confusion, it was certainty. Daniel asks why no one told him. The attorney answers honestly. Because from the system's perspective, they say, there was nothing to tell you. They explain that stabilization does not require agreement. It does not require notice. It only requires enough internal alignment that reversal is no longer anticipated. Daniel asks the question that has been waiting at the center of everything. So when did I lose? The attorney does not use the word lose. They choose their language carefully. You didn't lose, they say. You were processed. Daniel thinks about every moment that felt pivotal. Emily in the witness chair. The compliance document on the table. The pen placed just within reach. The weeks of waiting. None of it was about persuasion. None of it was about discovery. It was about alignment. Daniel asks whether there was ever a moment he could have changed the outcome. The attorney pauses longer this time, then answers. Yes, they say, before the case was stabilized. Daniel nods slowly. That's the part no one tells you, the attorney adds, because you don't know it's the moment while you're in it. Daniel exhales. That is the truth. The moment existed. He just didn't recognize it as the moment. The record will show that Daniel Reyes's case concluded on a specific date. It will show compliance, procedure, finality. It will not show the earlier moment, the quiet one, the internal one, the moment the system stopped listening. Daniel understands now. The gavel did not fall at the end. It fell long before anyone entered the room. That is why no one heard it. The case is over. But the story is not, because Daniel Reyes is not the only one. There are other files, other names, other cases already stabilized, outcomes already protected. Those are the cases you never hear about, until now, before the gavel fell.